1:30. I'm hoping that everybody can hear me. Could you just give me a little thumbs up if you can hear me? That looks great. Okay, thank you. So good afternoon. It's now 1:30 or just after, and we can commence the third and perhaps final pre-examination meeting for the conjoined inquiry into the Section 36 applications made under the Electricity Act at Craiginmoddie, Carrick and Knockcronal in South Ayrshire. My name, hopefully you'll know by now, is Rosie Levin, one of the reporters appointed by ministers to consider the three applications. Mr. Bray and Mr. Reid are also present today and will participate as we move through the agenda, which I hope you've all got a copy of in front of you. And can I also double check that the parties have seen the airport's position paper that has appeared this morning? We'll get to that in a moment, but just I see nodding, so that's fine, thank you. As usual, this meeting is being recorded and broadcast live. Our technical staff are watching and available in case we have any technical difficulties. Hopefully we won't. And we plan to make the meeting available on the DPA webcasting site so that those participating today can also view it. I'd ask that you keep yourself on mute during the proceedings this afternoon, unless you need to speak at any point, and I'll bring you in at the appropriate times. I'd also request that if you're not the lead spokesperson, please turn off your camera to help manage the number of people that are on the screen at any one time, but it doesn't look like there's too many of us that I can see in front of me now, so it's fine. And also please switch off anything in the background that might make a noise. So if I could ask the lead spokesperson for each party to now introduce themselves and anyone else who may be participating today. Firstly, I'll start with the applicants. So we turn to Mr. Hardy first.
Yes, good afternoon then, David Hardy. You know who I am, so partner at CMS. I'm not proposing that I'll need to draw on anybody else, but I do have a couple of team members available. So Mr. Briggs from the client, I've got Mr. Keith Campbell in reserve, and on the end of the phone, I've got Mr. Parkinson, who is the aviation witness.
Okay, that's helpful, thank you. If I could move to Carrick now.
Afternoon, ma'am. Ewan McLeod. I'm a solicitor with Shepherd and Wedderburn, and I'm representing Scottish Power Renewables UK Limited, who are the applicant for Carrick.
And is there anybody else participating in your team today, Mr. McLeod?
I've got a cast of thousands around a table in the room with me, but I don't think they'll be needed today.
Okay, thank you. And Knockcronal?
Good afternoon, ma'am. My name is Vincent Fraser, King's Counsel. I'm instructed by Pinsent Masons on behalf of the applicant, and my instructing solicitor, Mr. Gary McGovern, is also on the call.
Okay, thank you very much. And if we could turn to Glasgow Prestwick Airport now.
Good afternoon, ma'am. I'm Ewan Brown, Counsel, instructed by Dentons on behalf of Glasgow Prestwick Airport Limited, and I am accompanied in the room this afternoon by Hannah Johnson.
Sorry, I didn't quite catch that name. Could you repeat it?
Yes, certainly. Hannah Johnson.
Sorry, it was just there was a bit of interference on the line. That's fine. Thank you. And finally, is South Ayrshire Council with us today?
Yes, ma'am. I'm Douglas Armstrong, King's Counsel, appearing on behalf of South Ayrshire Council, instructed by them, and I have with me today, and who's also on the line, Steve Callan, Senior Associate Planner at Stantec, who acts as the planning representative of the council.
Okay, that's great. Thank you. Nice to see you all today. So if we could move to item 2 on the agenda, the purpose of today's meeting is to discuss the arrangements and the next steps for processing these cases following the postponement of September's aviation inquiry session. We are aware now that a judicial review has not been raised in relation to the Minister's decisions on Clockery or Sanker 2. So we would like to set out the options and to understand your views on that today. And taking on board those views, we hope to agree the approach today and confirm it in the note of the meeting. Obviously, if we can't agree, then we will have to take the matters away and consider them further and set out our decision on the approach in the meeting note. But I do hope that we can agree today if possible. So just to recap, we asked you by the 30th of November to come forward with any updates to the statements of agreed matters on aviation and any agreement on aviation related conditions. We understand that this has not been possible, but under item 4, we will look for an update from the airport on the assessments relating to the outstanding concerns, and obviously the airport can pick up on the matters in its position paper at that point. We also asked you to come today with views on dates for possible oral sessions, and we've seen the communications on that from the start of last week and again in the airport's email this morning. And we'll get into these matters shortly, but I just want to emphasise that today's meeting is a meeting on the procedural matters, not the substance of the outstanding issues, and the merits of the cases or any evidence relating to them will not be discussed. So before we move on to item 3, are there any questions on the purpose of the meeting? People happy with what we're covering? Okay, great. So item 3, the statement of agreed matters. Obviously, we understand the context for where we are and the importance of the issues involved, but nevertheless, we are rather disappointed, I think, that no updates have been made on the statements, given that we requested them by a particular date, and we know that the airport's position has changed, and at least one issue is no longer a matter of objection. So, and we have also tried as much as possible to be amenable to the airport's request for further time to consider the matters that have caused the inquiry to be postponed. But obviously we're now sitting well over 3 months since those matters arose, so we do need to try and move forward. So in terms of the statements that we have statements of agreement between the airport and Carrick and between the airport and Craiginmoddie, which date from, I think, the end of March this year. So we need to understand their status and how we should regard them now. Are they still accurate? And we'll talk under the next item about the assessments that the airport is undertaking, but we wanted to know whether it was still the airport's intention to work with the applicants to update the statements. So perhaps if the airport could give us a view on these matters first, and then I'll ask the applicants for their views. Mr. Brown?
Thank you. So far as the airport is concerned, its position remains as outlined in its letter to the DPEA dated 21st September. The reason why it's not been possible for the airport to progress with updating the statement of agreed matters is because it continues to have dialogue with the CAA about the issues which arise, and it's endeavouring to bottom out the position of the CAA in relation to the technical aspects which are of concern, ma'am. The airport is by no means trying to be difficult about this at all. There has been a request for communications with the CAA or correspondence with the CAA to be produced, but ma'am, the position is that the communications with the CAA have taken place by way of meetings. There have been 2 meetings. First of all, there was a meeting on the 12th of September, and following that meeting, it was agreed that there would be a further meeting with the CAA, but given the breadth of technical input which was required, it proved impossible for a meeting to be fixed until the 11th of November, which was certainly later than the airport would have wished. The airport, having had the meeting with the CAA on the 11th of November, anticipated that the CAA would get back to it, but that did not happen. The most recent position, ma'am, in relation to the CAA is that the airport wrote to it again on Friday last week to encourage it to respond on the technical matters which are of concern. Now, with regard to the sharing of the communications, the airport, in its communication with the CAA on Friday, inquired whether the CAA considers that any issues of confidentiality arise in relation to the discussions which are taking place to date. If the CAA comes back to the airport to say that it's satisfied that no issues of confidentiality arise, then the airport will lodge the communications and correspondence with the CAA. However, if the CAA comes back and says that, as far as it's concerned, the communications are protected, it will be necessary for an order for disclosure to be made by the applicants. They have suggested that they may do that. And if the applicants bring forward such an application, then the airport will have to consider its position at that time, having heard from the CAA. But it may well be the case that the airport will not object to the order being made, should it be so. So in summary, the airport has endeavoured to make progress with the CAA here, and it would very much want to be in a position to report today that progress has been made, but the extent to which it's been possible to do that is beyond its control. It's in the hands of the CAA at the moment.
Okay. Before I ask the applicants for their views, could I just check whether there's any sort of timescale on your request for that response from the CAA? Was there a deadline given, or is that open-ended?
Well, no, ma'am. Being acutely aware of the fact that progress has to be made, the airport asked for a response before the Christmas break.
Okay, thank you. I'm conscious it's straying a little bit into the next item, but I think I will ask the applicants for their views at this point. Mr. Hardy?
Yes, thank you, ma'am. Well, a number of points. Strength of feeling on behalf of my clients is well known. That's been expressed in the correspondence. And there is a feeling that, quite contrary to what GPA have just said, they're actually holding this inquiry process to ransom, and it's taking far too long. So, of course, it isn't just September. The original sessions were going to be June. So that needs to be borne in mind in timescale terms. Secondly, I think the feeling is that the airport's trying to change its case, and the issue of probability of detection is a new matter. And it feels as though, having lost the Sanka case as heavily as it did, it's then been scratching around for a new case, and we're troubled by that. So it's not that any other party to an inquiry is given the opportunity to recast its case and take a long time to do so. So the backdrop is that. The third thing, in relation to documents, is that we've not been in a position, as you know, to progress the SOA much as we would have liked to do, because we simply don't know what the airport's case is. So, although it's a matter of regret from all parties that progress hasn't been made, I wouldn't want you to think that any of that really lies at my client's door, because we absolutely do want to have a SOA, but we don't know what the airport's case is. So, just to make that plain. Fourth thing, in relation to documents more generally, the picture that's been painted by the airport is that nothing in writing has been recorded. I find that very hard to believe. That's the conversations apparently all being verbal. So we've made repeated requests for sight of documents. It isn't just the CAA. We were told in the letter of the 21st of September from Denton's that there was a report from NATS, and that's on the final page. It's page 5 of the document, and it's halfway down the page when the paragraph reads this: due to the CAA's expectation for coverage of the airport's radar and the report from NATS. So there is something in writing. We've asked for that. It's not come, being given no explanation as to why that is. So we would like to see that and any other correspondence, because we don't buy that there hasn't been anything in writing. And I think the fifth point is this: our position remains that we, having seen Sanka, we had the sort of Damocles hang over us for 3 months. Do we? And actually, that didn't come to anything. So the position is that the conditions, we say no further procedure being required, will sort this out. Now, I suspect that is unattractive to you as decision makers, and we understand that. We think that you could deal with it in writing. But if not, there are going to be oral sessions, then we think there are certain sort of preconditions to that. And one is that the airport is asked to articulate its case, and we think that ought to be done in a supplementary statement of case, and we'll come to dates, but so maybe the 31st of January or something like that, where the airport has to pin its case down. It has to say, this is what we're arguing. These are the references. These are the technical points that we're going to kind of raise. Because the position paper that came out this morning really doesn't take us anywhere. It's so skeletal. We can't prepare anything on the back of that. Final point is this. I just want to clear up an inconsistency, if we may. In the letter, so Mr. Brown's just told us that the position hasn't changed since the 21st of the letter of the 21st of September. On the first page of that letter, issues remaining in dispute, there are Roman 1 to 3. So the adverse effect of the proposals on probability of detection. Then 2, the adverse effect of the proposals on VHF communications. And then 3, the cumulative impact in respect of both of the above. So cumulative, but limited to points relating to PD and VHF. When you look at the 3-page statement of case today, it's little 3. The principal matters. So there's a bit of a change there. In the original letter, the key issues remaining in disputes, it seems to me more tightly worded. But the principal matters to be considered are then airport's position on PD, impact of the proposed events, and then cumulative impact. Now, that isn't limited in the way the letter was, cumulative impact to PD and VHF communications. And it feels to us there's a real danger lurking in the statement of case today. Cumulative impact could open up the whole shooting match. So I just want to make clear through you that actually the cumulative impact is restricted in the way the letter of the 21st of September was. So 6 points. They are, reasonably substantial points. I hope that they've been made clearly enough for you to take a note, but that articulates that sense of frustration that we've got.
Okay, thank you. I'll turn to Mr. McLeod. I will come back to the airport just to pick up a couple of points after Mr. McLeod's had a chance, and Mr. Armstrong, if he wishes. Mr. McLeod?
Thank you, ma'am. Yes, my clients similarly share Mr. Hardy's client's frustration at the approach that's been taken to date. Mr. Brown indicated that the airport's position remains as set out in the letter of 21st September. Just to reiterate, and you'll have seen this before in correspondence, the airport's position is that it may be possible to mitigate the adverse effects of the proposals. The outstanding issues are not therefore fundamental objections. And that, I would submit, is the context in which any further procedure decided on today has to be considered. Now, to go on with the letter of 21st September, in a nutshell, it effectively says the airport doesn't know what the position is, and it's all down to the CAA. Mr. Brown has indicated today that the CAA have not yet spelled out their position, and we don't know when the CAA will. We have a practical suggestion for that, which we'll come on to in due course, which is conditions requiring sign-off by the CAA. And I still do not understand what would be wrong with that approach, standing what the airport has now said in its limited position paper today, and we can come back to that. But I suppose to come back to the point of the question that you're asking, statement of agreed matters, my clients would very much have liked to enter into an updated statement of agreed matters, but it simply has not been possible because the airport has not disclosed anything that has happened since 21st September, or anything meaningful at least.
Okay, thank you. Would Mr. Armstrong or Mr. Fraser want to say anything at this point? Mr. Armstrong?
Yeah, Mum, perhaps at this stage, all I'd say is that obviously, as we set out before to an earlier pre-inquiry meeting, that the council's principal involvement in relation to aviation is in relation to the conditions. We've obviously set out a policy objection in relation to aviation. We were not going to participate in the inquiry session other than in relation to the conditions session. And perhaps if we come back to that when we deal with that issue.
Okay, great. Mr. Fraser?
Thank you, ma'am. Well, ma'am, our position is slightly different in that you know that conditions have been agreed with us. So we haven't actually been taking any part further in these proceedings. So we obviously have an interest to see what's happening, but we haven't been involved in them. I think our interest comes really, I suspect, in item 7 of your agenda, because we are frustrated that our case is still being held up, but that's perhaps something I can comment on later, ma'am.
That's fine. I think I will maybe just bring in Mr. Armstrong, Mr. Fraser. I'll bring you in, as you say, later on in the agenda. So if there's anything particular you want to say as we're going along, if I haven't brought you in, just please put your hand up and I'll do that. So I think I'd like to go back to Mr. Brown just to come back to the sort of purpose of item 3 on the agenda, the statement of agreed matters, and whether there was a plan to update them insofar as the matters that have now been agreed between the parties. Obviously, there are still matters that are not agreed, but is it still your intention that you would update those statements?
Yes, ma'am, it is, but the reasons explained, the airport has equally been frustrated by the lack of progress and has not, as a result, been able to have discussion with the applicants about updating the statement of agreed matters. But the intention is that we'll have those discussions to update them.
But there clearly are matters that there is agreement on between the airport and the parties now.
Yes.
So yes. Is there any sort of quicker way that we can get an update on those matters, get the statements updated on those matters, while these other outstanding matters are still being considered?
Well, certainly, ma'am, yes, the airport will liaise with the applicants on those matters which have been agreed, which remain applicable, if that's your question, ma'am.
Well, yes, I think we would want progress as far as it's possible on the matters that have now been agreed.
Yes,
and that's really what we were looking for by the 30th of November. So any sort of quick progress on that before the Christmas holidays would certainly be appreciated.
Yes, well, the airport will undertake to do that.
Right, okay, thank you. I think we'll just move on to item 4 then, which we have covered a little bit of in that discussion already. But I guess we would look for a little bit more of the specifics around these 3 different strands. Obviously, we're not here to discuss the actual detail of the matters themselves, but it's really about following up on those timescales that you'd indicated in your 21st of September letter. You've said a little bit more about those timescales now. But is there anything else that you can add in terms of the detail for each of these individual strands, Mr. Brown?
Ma'am, there's nothing I can usefully add in addition to what I've already said. The fact is that they are difficult technical issues, and the point has been made before by the airport that it finds itself in an unprecedented position here and having such intense wind farm development within the vicinity of its operations. And the intensity of that development is throwing up challenges for the airport and for the technical advisors the airport has employed, because it is such a unique situation. The airport's intention was to establish the regulator's position, i.e. the CAA's position, having discussed the technical issues with the technical advisors within the CAA, and the intention was to do that in relation to the measurement of probability of detection, how the airport should deal with the fact that the methodology provided in CAP 670 so far as VHF communications are concerned had not been met, the test had been failed, and to establish the CAA's position in relation to cumulative impact. And the issue there, just to go back to a point which Mr. Hardy raised, the issue in cumulative impact is actually the issue which was outlined in the letter of the 21st of September, namely that if this, and this is to be found in issue 3 on page 4 of the letter of 21st September, if the airport's position in relation to the proper calculation for PD is accepted, the cumulative effect of Carrick and Craiginmoddie together with Knockcronal, Hadgertal and Stirling will be to create a string of wind farm development stretching over 10 nautical miles in length, over which the PD will have been impaired. And of course, the other point, ma'am, is it's critical airspace for the airport. I'm conscious, ma'am, that you indicated you didn't want to go into the technical detail at this stage, but I thought it was worth clarifying that point since Mr. Hardy had raised it earlier.
So could I just repeat that back to you then? So are you saying that you agree with Mr. Hardy that the cumulative impact is focused on items 1 and 2 in that letter? It's not broader than that?
It's not. If Mr. Hardy was concerned that the airport is about to open up a discussion about the cumulative impact within the entire operational range of the radar, the answer to that is no. It is focused on the cumulative effect as outlined in the letter on 21st September, and in particular, as highlighted in the first paragraph of issue 3, to which you've taken, Imam.
Okay, that's fine. I'll come to you in a minute, Mr. Hardy. You'll be able to respond to that. I just wanted to ask you a further question, though, around, I think you had given an indication previously that the CAA might be in a position to gather the evidence that was necessary for you to update your position by the end of the year. So is there any sense from the CAA that is going to be the case, or any other indication that they're giving of timescales?
There's no indication of that at the moment, ma'am, but the airport is endeavouring through various channels of communication which it has with the CAA to ensure that the CAA treats this as a matter of priority. Okay, so no fixed timescale at this point? No fixed timescale, ma'am. If I had a fixed timescale, I would share that with you without hesitation. But as I indicated earlier, the airport is in the hands of the CAA on this particular point at this stage in time. Okay, and do you have any comments on the contribution that NATS may or may not make, as highlighted by Mr. Hardy? Are you having discussions with NATS as well? There have been discussions with NATS in addition, ma'am, but they're not well progressed at the moment. Could you expand on that a little bit? I mean, well, there was one meeting with NATS to discuss the airport's concerns about how probability of detection had been measured, and it has recently been agreed that a further meeting with NATS will be required on that. And do you class their input as critical to you framing your final position? No, ma'am, we don't, because the airport's position is as stated in the letter, and it has a response. The airport has a responsibility for the safety of the airspace in terms of the license which it holds, so it will ultimately have to make a decision. But so to that extent, NATS is not material. But obviously, what is a material consideration for the airport is how the CAA, as the regulator, views the airport's position. Okay, that's helpful. Thank you. If I could turn to the applicants now, please. Mr. Hardy, would you like to comment on anything that's been said?
Very briefly, just listening with interest. I mean, I find that very hard to deal with, because the airport's had 2.5 years post Sanka to raise what is a new issue. This is a pivot. In its case, it loses, it goes, oh my goodness, what are we going to do? We'll find something else. And we know from the letter, penultimate paragraph, that as a result of further investigations conducted by Mr. Fido shortly after the preparation of his original report for the inquiry, I mean, that tells you a little bit about the difficulties that the airport appear to be having with the inquiry timetable. So I'm not buying the time. This is not a new issue. They've had years, and what they're doing is changing their case because they realise that they lost heavily at Sanka. The second thing is in relation to NATS. Mr. Brown hasn't given me a response to my request for the NATS report. So again, I go back to the letter of the 21st of September, final page, middle of the document, middle of the letter, where there is reference to a report. There's conversations with the CA and then a report from NATS. Well, let's have it. It is not, we've asked for it 3 times, I think it is, and we've been told, well, we've just been stalled, basically. So we would like to, through you, to make a request for that. And I think more generally, you're aware, I'm sure, Ma'am, GPA were quizzed by the Scottish ministers at the Economy and Fair Work Committee last week, and it's an interesting watch. The airport then said, well, they've got new evidence. It was in the past, so that as in we have got lots of new evidence, which in relation to the inquiries that are going on, presumably that includes Craiginmoddie. So we'd also like to see that as well. If we're giving answers to the Scottish ministers that they've got lots of new evidence, well, we need to see it now. So again, through you, make that request. Final concern really is timescale. You've heard this is all open-ended, don't know, CAA can't give you a fixed timescale. What does that mean? A year, 2 years, 3, whatever it means. There's got to be an end to this, and GPA has to, put up or shut up. We have the inquiry sessions, it makes its case, and if it loses, it loses. I'm afraid it can't go on in this way.
Okay, Mr. Hardy, thank you. Mr. MacLeod?
Just very briefly, two points. One in relation to the airport's duty to ensure safety. The CAA has the ultimate role to sign off the safety case. And our position, and I think this is the position of the Craiginmoddie applicant as well, is that it's appropriate to have a condition that involves the CAA signing off whatever mitigation is required. So, although I think we can probably all appreciate that the CAA will have numerous things on its plate, and that this may not be a top priority for them to resolve before the end of the year. The CAA has ultimate responsibility for safety at this airport and the interaction between the wind farm proposals and the operation of the airport. We're putting forward a proposal that addresses that. And just to pick up on what Mr. Hardy has said about the committee last week, I hadn't intended to raise it, but since he has, we do have concerns about that. We have the chief executive, I think, of Glasgow Prestwick Airport refusing to answer questions to the Parliament, saying that it's linked to the new public inquiry that's coming up in the new year, and there is significant new evidence connected to that. It's an ongoing position as far as we're concerned. Now, we're unaware of what that evidence is. One thing that was clear from that meeting, and we will be lodging a copy of the committee report, but when the Energy Minister gave his evidence to the inquiry, he noted that the airport had a commercial interest, but he fully expected the airport to comply with the reporter's recommendations and with the direction that has been given by Scottish ministers. Now, that direction, as you will appreciate, is that suspensive conditions should be put in place to mitigate upfront impact, but that the sort of agreements that the airport would like us to sign up to are no longer appropriate, if they ever were.
Okay, thank you. I might just come back to Mr. Brown before we move on in the agenda. Is there anything you'd like to say in response to those matters, in particular the issue of whether there is new evidence and the access that the parties can have to that evidence?
Ma'am, I've not spoken to those who were at the committee meeting which has been referred to, but the new evidence is the points which were made in the letter of the 21st of September to the DPEA.
Well, that's the sort of headline of the evidence, but it's not the evidence itself.
No, No, ma'am. There is no secret stash of evidence which has been withheld from the inquiry here. If that's the concern, that has certainly not happened.
Okay, and obviously we're trying to get to the bottom of what the evidence is at some point soon, so that we can kind of move forward. So that's, I guess, where we're at. Okay, I think I'll move on to item 5 and 6, which will quickly take us into item 7, which is probably the nub of the issue. So item 5, again, obviously no updated conditions have been submitted at this point. So I was just going to propose that we run that into item 7, unless anyone has any other specific points on conditions. I think some points have been made on that already. Are people happy that we just run on through with that? Okay, and item 6 on aviation lighting, this was just to sort of flag up. We'd indicated at the inquiry sessions back in May and June that we did have some questions relating to aviation lighting, particularly around the operation of the and the implementation of the ADLS. And I think these could be dealt with by further written submissions, but it's just to flag up that we will need to address that at some point, and I'll pick that up under the next item, if everyone's happy. Okay, so item 7, obviously we are keen, I'm sure many of you are, to push ahead with completing the inquiry and finishing the reports as soon as we can. And on the basis of what we've read and heard, there are 3 main options. So we'll just run through them quickly, and then we'll have a bit more discussion about your views on those options. So the first option would be for us to reschedule the aviation safety inquiry session, and we think that could be done over a slightly shorter number of days, given that some of the airport's original objections have now been removed. The second option would be to reconvene the conditions hearing, which we held, I think we had the first session back on the 20th of June. And again, given that some of the airport's objections have been removed, this would really focus on the extent to which there's agreement around the conditions to address the outstanding concerns. And given the shorter run-in times for evidence and the lack of cross-examination at the session itself, this would be a slightly quicker option. And the third option would be for us to hear no further oral evidence, but to consider a final set of proposed conditions as put forward by the parties, alongside evidence that's already been submitted, hopefully updated statements of agreement and further written submissions on matters relating to those aviation conditions, plus, as I say, a few outstanding questions that we may have around aviation lighting. So I think I'll ask for your views first, specifically on which route you think is the best way forward. Obviously, I think I probably know which way you will go, but I would like to understand your sort of reasoning behind that as far as possible. So I think I will ask the applicants first. Again, if you don't mind, Mr. Hardy, you're going to come up first, please.
Thanks very much. Well, as matters stand, and our view of the airport's case, we think that that writing and conditions would do. However, that's subject to a big caveat. We simply don't know what the airport's case is. And, if they're now saying, well, there's this major critical issue, we're going to produce evidence on it, then that much as I don't like to say this, it feels as though that has to be tested at an inquiry session. I certainly don't want that sort of material to come in and then to have an informal hearing. If it's coming in, then I think it's got to be rigorously tested. So I think it's either option 1 or it's option 3. I don't think having anything less than that is sensible. What I do think is, and repeating the point I made earlier on, is to have an updated supplementary statement of case, and that ought to be one from the airport, not asking us to put in something simultaneously, but a document which details what the airport's case is, the evidence it's going to rely on, the documents it's relying on, and it feels as though the end of January may be about right for that, and we're given maybe, I don't know, a month or 6 weeks or something like that to respond. That all ends up, if we are going down the inquiry sessions route for, I think, about April. I think I noticed in this morning the airport said that it had got dates in April. It feels to me the last couple of weeks in April would strike a balance in that situation. So just to be clear, absolutely want this to move on. We do think that you've got enough conditions will do. But given what I've heard today and the vagueness of it, we want to have absolutely the chance to look at that, test that, and put the, I'm afraid, put the airport to the test in public again. So I suspect an inquiry session is going to be the regrettable necessity.
Okay, thank you. Mr. MacLeod?
Thank you, ma'am. I'm going to depart slightly from what Mr. Hardy said. I think that in essence, where we are now and where we're likely to reach by, say, February, March of next year is not going to change very much by the sounds of things. That said, we think the position is quite clear. We have a clear direction from Scottish ministers about the way that they want to see wind farms and aviation issues dealt with going forward. We have suspensive conditions proposed. We see no difficulty with attaching suspensive conditions involving the CAA to these proposals. And although there is no doubt further discussion that will need to take place between the airport wind farm operator and the CAA over a period of time, that can be done out with the inquiry process once consent is issued, if the consent is issued. And our position is that the issue should really be dealt with now on the basis of the conditions that you have, or alternatively, if you feel that you need specific input on any of those conditions, by all means, ask specific questions of the various parties and allow us to focus the issues that remain outstanding in your minds. But we believe that conditions is the way forward here, and a public inquiry session is really not going to assist you any further than you have been to date.
Okay, thank you. Did Mr. Armstrong or Mr. Fraser want to add anything before we go back to Mr. Brown?
Perhaps just on the conditions issue, there have been discussions in the past involving the council in relation to the conditions. Mm-hmm. The wording has not been agreed between the parties, but there had been some movement in relation to the wording, and the last position the council had was that they were waiting for a response from the applicants on that. So
can you advise when that, what the timing of that was, just so that we can track back on the right set of conditions?
There was discussions back in, I think it was June last year, the 6th of June, and there was obviously the set of conditions that went forward to the last hearing in relation to conditions. The council's position is, as matters stand, that they would still want to be involved in any conditions session, yeah. Although there is a possibility that matters could be resolved between the council and the applicant in relation to the wording, but at present the matter isn't resolved. Okay,
thank you. I'll maybe come back. Mr. MacLeod, do you want to come in?
Could I just ask for clarification through you, ma'am? Is that related specifically to ADLS rather than the overall aviation condition, Mr. Armstrong?
It's the overall aviation conditions, which I think were 5 and 6.
So can I just be clear that you're saying that following the last set of published conditions that we would have seen, there has been further discussion, or do you mean that there was further discussion in the run up to that last set that we would have seen? Mr. Armstrong?
Sorry, Mum, I lost you completely there.
Oh, sorry.
And then in the link, perhaps if you could.
Okay, I was just asking for clarification about whether there has been further discussion since the last set of conditions that we would have seen. Is that what you're saying?
That there's been no further discussion since then, right. Certainly involving the council.
Right, okay. Hopefully that answers Mr. MacLeod's query as well. So Mr. Fraser, did you want to say anything at this point?
Yes, if I could, please, ma'am. As I indicated before, ma'am, we think our position is different because the conditions with respect to our application are agreed. So in that situation, I don't want anything I say to be thought to be commenting one way or the other about the matters between the other two applicants and the airport. I leave that entirely, obviously, to yourselves, ma'am. But given that the conditions in our case are agreed, we don't believe there is anything more that needs to be dealt with our application. And if there were anything more that needed to be dealt with, it could obviously be dealt with very quickly and briefly in writing. And so, ma'am, we really are very concerned at the prospect of our case being delayed even further, because in reality, our case was finished in August with the closing submissions. And so if the decision is taken that there is a need for further procedure, which is going to delay effectively determination of this matter or the normal processing of this matter beyond, say, next month, then we really think, ma'am, the time has now come when our application should be separated from the other two and taken forward in the normal way for determination.
Okay. Thank you. I'll come back to Mr. Brown if you'd like to make any comments on your preferred route. Obviously, we've seen in your paper this morning your current position, but is there anything else to add to that?
There's nothing to add to it. The position is as outlined in paragraph 5, but I can perhaps just amplify a few aspects of it. First of all, so far as the proposed condition is concerned, it's posited entirely upon Terma being able to mitigate the adverse impact of the proposals to an acceptable extent. And there is no guarantee that that will in fact be the case, meaning that alternative mitigation will have to be looked at. A similar point arises in relation to the VHF communication, in that there is no condition at the moment for mitigation of impact on VHF communication, because simply put, both of the applicants who remain parties to the inquiry do not accept that there is any adverse impact which requires mitigation, and that's a position which the airport cannot accept from a regulatory perspective. The methodology set out by the CAA for calculating the impact is not met, and as a result, the airport must treat that as meaning there is a safety issue which has to be addressed. And finally, there's the issue of cumulative impact, and it's already been indicated, certainly by the Carrick applicant, that the issue for the airport is pre-existing. So there are significant financial disputes between the parties, and it's impossible to see how they could be resolved in the context of trying to draft a condition. And the point is made in paragraph 5 of the airport's position paper that even if such a condition could be agreed at this point, it's simply going to store up difficulty several years down the line. The issue is not going to go away, and it's much better to deal with it now and achieve certainty as to how it will be addressed should permission be granted for these proposals and they are built out.
Okay, thank you. I might just go back to the applicants, if you don't mind, just on the principle of the issue about whether conditions could deal with all 3 matters that are outstanding effectively. It sounded like Mr. Brown thought that just one of them was being covered, but Mr. McLeod, you were raising this in more detail. If you could just say a little bit about whether you think that all the matters can be addressed by conditions.
Yes, certainly, ma'am. So probably the best place to look for this, because we've addressed it to some extent already, is an email that or a letter that I'd sent by email to Morag Smith on the 16th of October, and you can have a look at that post-exam meeting. But in essence, on VHF impact, our position is that there isn't an impact that needs to be resolved, but that if you had concerns that there might, you could put in place a similar sort of suspensive condition that would require sign-off, again, involving the CAA as ultimate regulator. On cumulative impact, I'm not convinced that there's a condition that's required to address that, because as Mr. Brown's already said, the cumulative impact is really related to PD and or VHF impact. So in practical terms, what would happen is post-inquiry, and assuming that all schemes got consent, there would no doubt be discussions take place between technical specialists. They would draw up a scheme of mitigation, whatever that looked like, in order to ensure that the radar and VHF equipment operated effectively. And that scheme of mitigation would have to take into account the cumulative impact of the other wind farm proposals. And so by the time that something went before the CAA for approval, you would be looking at a finalised mitigation solution that they were being asked to sign off. So in that way, I do think that all of the issues can be dealt with by suspensive condition, if you and the ministers were minded to grant the various wind farm proposals.
Okay, thank you. Mr. Hardy, do you want to comment on that?
Yes, I mean, based on you've already heard me say this, but based on the evidence we've got before us, then yes, conditions are suitable, and that's the position that we put forward. But, and that's the big but, and it's the one I've made 3 times now, don't know what's coming. And of course, in terms of a conditions hearing, or you making a decision on hearings, you can only do that if you're happy that you've got sufficient evidence from all parties on specific mitigations that are required to go into that condition. So if the airport are coming forward with whatever they're going to do, raising a new issue, then it seems to me that that becomes difficult. So on the basis of what we've had, yes, absolutely. But I just fear, I'm saying it's a regrettable necessity. It feels to me as though we're heading down a route because the airport is forcing us down that route. The final point is this, is that, I hear what Mr. Fraser's got to say. It's not, not, but what I don't understand is how conditions, if this is a problem facing the airport, it's goes to the principle of detection, probability of detection, why it makes any difference as to what conditions have been agreed already. If it's good for one scheme, it's good for another, or it's good for none. And if there's either this massive safety problem that the GPA claim, or there's not. It can't come down to whether or not one side has signed up to a confidential agreement and paid some money.
Okay, thank you. I think what we might do is just have a short break for 5 minutes, and we'll just have a little conflab. We have I think, sorry, Mr. Brown wants to come in. That's fine. Mr. Brown?
Yes, sorry to interrupt. Ma'am, it was just to make a point which I realised I should have made earlier in response to Mr. Hardy's point about a statement of case. If it is of assistance, the airport is more than willing to provide an updated statement of case by, say, the middle of January.
Okay. Well, that's helpful.
Very grateful for that, Mum. All I would say is that it's going to be no use having the sort of skeleton that we've got this morning, and it would have to be a case which articulates the detail, of the argument that's going to be raised, including, the references, technical evidence that we can then genuinely go away and start to spend money, on rebutting. So very welcome, but it would have to be a substantive document rather than what we've seen already.
Okay, Mr. Brown, your hand's still up, but I take it you're not wanting to add anything else at the moment. No. Okay, Mr. McLeod.
Just to throw my tuppence worth in on that suggestion, and I think you have it already. I genuinely don't see that there is likely to be any meaningful progress between now and the middle or end of January, given what we've heard about the CAA's inability to engage on what's an important issue for all of those in this virtual room, but may not be a particularly important issue for the CAA at this particular point in time. And I genuinely believe that we will be a month down the line and we will receive a statement of case from the airport, which, although no doubt well-intentioned, will say we're terribly sorry, but we can't give you very much more information because the CAA haven't helped us here.
Okay. Thank you, that's helpful. I think, as I say, we will just take a short break, given that there's the three of us involved, and we'll have a quick conflab and get back to you. So if we could just come back at 14:35, if you could just put your cameras off and mute yourself just now, but don't leave the meeting. Okay, thank you. Okay, can everybody hear me? Yes, great. Okay, thank you for that short delay. We're just having a little kind of head to head on what we should say and do. So I think taking into account everything that we've heard today and that we've read in the evidence that's been submitted so far, obviously part of the airport's objection has been removed and the position has changed. There are obviously some outstanding concerns, and there's also, you know, on the other hand, without getting into the detail of the evidence, we are, you know, sympathetic to Knockcronal's position as being tied to the other two, and we know that mitigation has been agreed on the Knockcronal proposal. So I think there's a few things that need to be kind of addressed for us there, and I think based on what the parties are saying, we believe that actually, essentially, we're talking about a further round of further written submissions to kick things off in order to try and get clarity on the positions. And I think that should move forward quite quickly following the agreement to the note of the meeting today. We would want to really push on and try and get clarity on those positions and get that out before Christmas. So I think we believe that with a further round of written submissions, it may be possible to progress things without a further oral session, but I think we need to have the backstop of a further oral session in the diary in the event that we feel we don't have enough evidence to go to ministers. So I think we will turn in a minute to look at dates, but let me just check. And I think just mentioning Knockcronal there, I think we do need to be in the position of being able to explain to ministers the sort of difference between those positions. So as I say, we've got one of the three cases where mitigation has been possible and conditions have been agreed, and the other two where they haven't yet. And so we need to get the airport's help and perhaps CAA's help on understanding those differences. And that needs to be part of the evidence that comes forward. I think there's also a question about whether we would want to include CAA in the written submissions procedure. And that's something that we'll have a think about before coming to a view in the note of the meeting. But that perhaps would be helpful at this stage, given where we're at. So yeah, we are keen to move forward as quickly as we can. We're sympathetic to the airport's position, but we're also sympathetic to Knockcronal's position. So we're trying to get the right balance there. And I think we would want to push on with written submissions and agree dates for oral sessions should they be required later. Are there any comments that people would like to make on that approach? Perhaps Mr. Hardy, do you want to start?
Obviously, sympathy is a matter for you to give out, but I hope you're sympathetic with my client's position as well. I mean, we absolutely have been messed around. I think the second observation really is one I'm just repeating. I don't understand, just because you enter into a commercial negotiation, how mitigation works for one party and not for another. So an explanation of that, I think, absolutely does need to, you know, form part of this. Third thing is, in the stages that we're going down, a written submission, but I think that ought, with respect, to come from the airport rather than asking for parties to put their positions in simultaneously. We can't really do very much more. So it's for the airport to set out in detail what its case is, and I've suggested that, you know, end of January, something like that. And then fourth point to make is in relation to dates, just weighing up how long these things take. If we do need to respond to something substantively, then the last 2 weeks in April would be our preference. I think the airport said it could do late April. There's the weeks of the 15th, the 22nd or the 29th, although that strays just into May. So the weeks of the 15th of April, 22nd of April, 29th of April.
Okay, I should clarify that is what I was meaning, that we would be seeking some answers from the airport first and perhaps CAA with
Fine.
a view to you then commenting on that. We're not expecting that you've got anything to comment on at this
Because
point.
we don't have anything new to say. That would be a futile exercise. Final point. I don't want to let this go. I've asked 3 times, and I hope it's just recorded. The NATS report that's referred to in the letter of the 21st of September. So that is evidence that's a report, not that's something that's coming. That is a report the airport's had. We'd like to see that. And just confirmation on that point from the questions in Parliament about the additional evidence. It's perhaps slightly unorthodox, but it would be a request for full disclosure, really through you, that we don't want to be met with dribs and drabs of this. If there's information that is going to assist, we'd like to see that. And I think in any note from you, Mum, we'd like to see you make that request.
Okay, we'll come to Mr. Brown again in a minute. Mr. MacLeod, would you like to say anything at this point?
Very little to add other than to endorse Mr. Hardy's request for the NATS report. It was never clear to me when I read about it in the letter that it had any relevance to this inquiry. So it would be useful to see that and just be able to rule it out.
Okay. Mr. Brown, would you like to respond on the general approach that we want to take of seeking further details from you in the short term and holding an oral session as a backstop, and then also on the specific matters about disclosure of information?
Yes, thank you. So far as the general proposal is concerned, the airport would have no objection to that, subject to ensuring that there was sufficient time to allow it to frame an appropriate written submission. You will recall, ma'am, that I mentioned earlier that the airport had asked for a response from the CAA before Christmas, and I'm concerned that if the deadline for producing a written submission was just before the Christmas holidays, there might not be enough time for the airport to frame a response if it has input from the CAA before the Christmas break. So I would propose, ma'am, that the airport is given until the end of the second working week in January for its written submission to take account of that factor.
Yeah, if I could just clarify, it wasn't my intention that you would be asked to respond before Christmas. It was our intention that you would be asked the question before Christmas. Yes. And we'll obviously have to go away and think about the deadlines and how that might all fit in. But no, we're certainly not asking you for the response before Christmas, unless of course you are clear on what the answer is.
Thank you, ma'am. That clarification is very helpful. Thereafter, so far as disclosure of the further information is concerned, then the airport can make the NATS report available and it will disclose, it will have further communication with the applicants about what was said at the Scottish Parliament Committee meeting.
I think, yes, we would want, perhaps if there's a transcript or whatever, that'll be made available to all of us, and also the NATS report if that's relevant to us.
Yes.
Okay, well that's certainly helpful. Anybody else want to make any comments? Mr. Fraser.
Thank you, ma'am. Well, certainly with respect to, I'm happy with what you're saying with respect to Knockcronal. The only point I would make is that certainly with respect to Knockcronal, I don't see that that's dependent upon any response from the CAA. And so I really don't want that being held up. I think Mr. Brown suggested they'd have an overall response in any event by the end of the second week of January. And I certainly don't see why we should have to wait beyond then. I would actually venture probably could be done before Christmas, but certainly I'd be very concerned if it was going beyond the second week in January, ma'am.
Okay. Any other comments? Okay. Right, so I think we have agreement that we'll press ahead with a request for information from the airport, and then there will be an opportunity for the applicants to respond to that. And we will work out the dates for that after the meeting today. So if we could just turn to item 8, that was looking at the possible dates for an oral session. So it looks like, from what Mr. Hardy's saying and the airport, we're looking at possibly dates in the mid to the end of April. Are there any, could we perhaps get to a point of fixing dates today? Because obviously we don't want there to be further slippage and we want to make sure that we have dates available. I wonder if Mr. Bray and Mr. Reid can just make sure. I don't think I've got any issues with any of those dates, but you can have a think about that as well while I'm asking the others. Mr. Bray's got his thumbs up. Mr. Reid's nodding. Okay. Are there any concerns with any of those 3 weeks from any of the other parties? So that's the 15th, the 22nd and the 29th. Mr. Brown.
Ma'am, I should just indicate that it's believed the airport's expert air traffic control witness is not available during that fortnight, but it may be once the written submissions have been exchanged between the parties that there is in fact no need for expert evidence from Mr. Kirkland to be put before the inquiry. If there is an issue, the airport will certainly endeavour to try to find a workaround for that.
Well, Mum, I'm very concerned about that. We got the email this morning telling us that the airport had got availability through April. The absolute last thing we need to do is build in a backstop of an oral session where there is any wriggle room for the airport to say, "Oh, I'm sorry, we can't make it."
Yeah, I'm just going back to check what the position was. I think Sarah said this morning that there was good availability between the 1st and the 26th.
Yeah, that was what the airport told it. That's what the airport told us at 11 o'clock this morning.
Is that position changed then, Mr. Brown, or is it simply that one of the witnesses wasn't considered in that?
We're just having that point checked, ma'am, at this very moment.
I think my preference would be to go for the earliest of the dates that we can possibly make, which would be the week commencing the 15th.
Yes, well, indeed, ma'am, the airport has no objection at all to meeting those witnesses who are available. It's only the expert air traffic control witness who may have a difficulty that week. But as I said, his evidence might not be required once we have bottomed out the position following exchange of written statements.
I mean, that leaves us in a slightly difficult position because we don't know whether we can proceed or not.
Well, Matt, if I can just clarify this point, it has emerged during the call. I thought it had been addressed in the email, which was sent earlier, but perhaps matters have moved on. I will check it with my instructing agent just now.
Mum, can I just, I know Mr.
Hardy.
Yeah, but just to say, I mean, that's really unfortunate. What I don't want to do is obviously bake in an inquiry session where potentially key members of the airport's staff are not available. That's just not sensible after all of this. But also, I heard that there were 2 weeks that he's not available, and there are 3 weeks that I've suggested. So hopefully, one of those 3, we will be able to.
It's worth waiting a moment to see if we can actually bottom this issue out while we're on the call. So, Mr. McLeod, do you want to come in the interim?
Yeah, just one point, and I'm just reading from the Code of Practice on Electricity Inquiries, paragraph 19. The availability of parties' first choice of legal or expert advisors or technical witnesses will not be accepted as a basis for delaying the start of the inquiry. Now, I had been intending to make that submission in relation to the earlier dates that I had suggested for the Erigale inquiry. You'll remember my email from last Monday suggesting that Scottish Power Renewables were willing to give up that slot if you were available and if the Erigale reporters were agreeable to that, where we have a full week when the airport's witnesses are available. I understand that Mr. Hardy's team's available, and the only person who's not available is the airport's King's Counsel, who has only recently become involved in this process And in my submission, certainly according to the inquiry guidelines, it is not a good reason for delaying the start of the inquiry if that is necessary.
Okay, let's just pause for a minute and see whether Mr. Brown thinks he's going to be in a position to clarify availability of those April dates first.
Well, ma'am, I've got to admit that the email did say that the airport can offer good availability on the 1st to the 26th, and then it's caveated save for some discrete witness availability, and that was a reference to Mr. Kirtland's availability, ma'am.
So can you clarify when he is available for certain within that period?
Well, I can't at the moment,
Okay.
ma'am. I'm sorry I've been taken by surprise by this particular point. It should have been clarified before now, but I will endeavour to clarify that within the next 24 hours.
Right, okay. And in the meantime, could Mr. Hardy just confirm whether he was available and anybody else who needs to be available at the dates which the Errigal wind farm have set, which I think is the 18th to the 24th of March? Can I just
Yes.
check so that we've got that in the mix?
Yeah, we can't do that week.
You can't do that one, right? Okay.
No. We can do any of those 3 weeks in April.
Okay, so I think we would want to try overnight to confirm that some of those dates in April, it looks like somewhere between the 15th and the 29th, or will be the first week in May, are available in principle for an oral session.
Mrs. Leaven, sorry to
No, please do.
Mr. Brown, do you think there'd be any possibility for clarifying availability if we took a short break?
Well, sir, if that assists me, I would certainly welcome that opportunity to go make a call at the moment.
I'd be happy with that, yep. Should we have another 10-minute break? Would that be enough to hopefully catch somebody on the phone?
I would hope so, ma'am.
Right, okay, let's go for that then. So it's
Right,
if we come back at 3:10. And if we need a little bit longer, let us know, but we'll aim for that first. Is everybody happy with that? Great, okay, thank you. We'll come back at 3:10. Everybody hear me okay? Mr. Armstrong, can you hear me? Yes, you can. Great. Okay, thank you very much for that little short break, and I'll maybe turn to Mr. Brown to see whether somebody's got a bit of a fright when they were having a nice quiet afternoon. Hopefully you've been able to get in touch with the relevant person.
Yes, ma'am. First of all, my apologies for delaying matters this afternoon, but the adjournment was very useful in that I've clarified that all parties are available for the airport between the 15th and the 26th of April.
Okay, that's very helpful. Let's just look at those dates then. Okay, so that's a 2-week period. Is there any preference from any of the other parties if we were to say allocate 4 days just as a backstop? Any preference on either of those weeks? Mr. Hardy?
I was just going to ask whether or not we're planning to do this virtually. That's a question I'm interested in.
Well, that's certainly the route that we were going to be taking in September, and I think there was seen as some benefits to doing it that way in terms of the airport presenting their evidence. So I think we would be happy to proceed on a virtual basis if others are.
Yes, indeed. So,
Mr. Brown, I think I'll just check that you were nodding there as well. Yes, that's right. Okay, so let's presume virtual. Yep.
fine. No strong preference. 20 seconds, a slight preference.
Right. Okay. And Mr. McLeod, have you got any preference?
We're okay. We're flexible.
Okay, well, I think I would prefer to go sooner rather than later. So I think we'll go for the 15th. I'm sorry, Mr. Hardy, that's not your top preference.
No, it wasn't a strong preference. That's fine.
I think perhaps starting on the Tuesday tends to be more helpful just in terms of getting everything in place if we need it. So that would be the 16th to the 19th of April. Could we agree on that? Is everybody happy with that? And we were just talking briefly in the break there. I think based on these dates, we're not expecting, based on the process that we're talking about, we're not expecting that we would necessarily need to reconvene the hearings condition. We would hope that we would be able to resolve conditions through the written submissions and the inquiry process itself. But I think within those dates, I think we would maybe retain the flexibility to have a short hearing session on conditions if necessary, bearing in mind that the council is not involved in the inquiry itself. So if that's okay in principle, we would retain that flexibility. Is that okay, Mr. Armstrong?
Ma'am, in principle, yes. Certainly, if there was to be a session, it would be helpful if you could provisionally perhaps sort of set the date for that, so as if the council's to be involved, then they would be available. And ideally, if that could perhaps be at the end of the week, that would seem the logical way of.
That's what I was going to say. So I think we would probably pencil in Friday the 19th for that, and we'll just see how we get on with the rest of the week. But hopefully that would be enough time. Okay. Right.
Can I just raise one point in it? It's this. I mean, this is down as a backstop, and clearly we're hoping that we don't need to get there. Is there merit in having a date or a meeting at which, I don't know, another sort of PEM, I hesitate to raise it, but whether or not we then make a decision as to whether or not an inquiry session is required?
I think that's certainly a possibility, and that's something that we'll have to decide on at some point on the back of what we get through the written submissions process. So yes, if we feel that's necessary, if there's any sort of ambiguity about how we need to move forward, then we would have another short meeting.
I think even if it's abundantly apparent to us that we couldn't report to ministers without holding an inquiry, then I think we would just exercise our discretion then and say that. As Mrs. Cleveland's outlined, if there's any doubt or we need a meeting, then we'd hold one. But if it's abundantly clear to us, then we would just not delay the process any further.
That's very helpful. It's very helpful. Yeah. I think the last thing anybody wants is uncertainty.
Yeah. Okay. Any other questions on dates before we move on to item 9? No. Okay, so item 9 was just to discuss the need for updated reports and statements. And based on the dates that we've now agreed, which are the 16th to the 19th of April, we would set out in the note of this meeting the timescales for updated inquiry reports and precognitions. And obviously that will link in with the dates around the written submissions process. So as a result, we expect some of the submission dates might be a bit tight, given that sort of period in between. But it's important that they are met. Otherwise, you know, we're going to end up with more slippage overall, and we don't want to risk those dates that we've just agreed. So so that's just to warn people that, you know, may be tight, but hopefully there'll be enough time to fit in all those necessary steps. And I've mentioned that we would keep flexibility for a conditions hearing within those dates. And I think we would just set the date for any closing submissions at the inquiry itself. I think it's too early to do that probably in the note of the meeting. We will have a note to do it at some point. Are there any questions around the preparation of updated inquiry reports or statements? No. Okay, that's helpful. So moving on to item 10, it was just a couple of matters that we had. There may be other things that parties want to raise, but first of all, I just want to take the opportunity to mention that we are likely to apply a couple of administrative holds on the case. And this is simply to reflect our usual practice that where there's delays to the processing that are out with our control, then we would put the case on hold. But that's not going to cause any further delays, and nor will the case be placed in SIS now, but it just helps us to more accurately reflect the timescales for our processing of the case so far. So is everybody happy with that in principle? Okay, thank you. And a very minor issue just around updates to the core documents list. Obviously, there's a few items, as we've been working through the evidence, there's a few items which have been referred to which are not on the CD list. I think the last version of which was the 21st of August. And plus, there's a few more recent items like the Cochrane and Sanker 2 decisions, and there will be further additions to the list through the submission of the new aviation evidence. So it's just to advise that we've got a kind of marker on that, and we'll be out in touch with you again about that, probably after the aviation evidence is complete, just to make sure that we get all these relevant documents on the list. That's all I wanted to ask. But is there any other matters that anybody else would like to raise at this point before I conclude the meeting?
I think this is even with regard to the core documents, but that it may well be appropriate that we request the documents that were discussed today through the note of the meeting. I think that was the NATS report and the committee meeting, or a transcript of that committee meeting. I think it may well be useful just to request that from the appropriate parties through the note of the meeting.
Okay, sounds sensible. Mr. MacLeod, did you have a question?
It's related to the point that Mr. Bray just mentioned there. So on the parliamentary report, I have a copy of it here, so I'm happy to provide that to you this afternoon. The NATS report, we're anxious to see that, and I think from what Mr. Brown was saying earlier on, there doesn't seem to be any reason to hold off disclosing that. So I wonder, could he commit to giving us that within the next 24 hours, please?
Mr. Brown?
If we could have until the end of the week, ma'am, that would be helpful.
Where are we at the moment?
Can I ask, is there any particular reason for that, given that it's mentioned in the letter of 21st September?
It is simply to be sure that the correct report has been identified.
Okay, slightly interesting, but we look forward to receiving it. I think as soon as possible, if you can send it before the end of week, that would be more helpful.
Well, ma'am, I'll ask both reports then, in that case, if there's two.
Or indeed all of them.
All of them, yeah.
Yes.
Let's have all the NATS reports.
Ma'am, I just wanted to take instructions on this and be sure about what report was referred to in the letter, and make sure that's the one which goes to the parties. And the airport will do that as soon as it possibly can, and no later than the end of the week.
Okay, I mean, it does sound like that should be possible to be done fairly quickly. So if it's possible to do it before Friday, that would be very much appreciated from our point of view as well as the others.
Of course, ma'am.
Thank you. Any other matters that anybody wants to raise? No. Okay. Just to conclude then, item 11. So as I've mentioned, we will go on now and prepare a note of the meeting. We will aim to circulate that within 7 days and sooner if we can, but we'll try and circulate that as soon as possible. And that will take into account our discussions today and the agreement around the dates of the 16th and 19th of April as a backstop oral session. And we'll set out the dates on the submission of further written submissions and the submissions relating to updated inquiry reports, etc. And the note will thereafter be on the DPA website as well. So if nobody has any other points, I'll just say thank you very much for your persistence and assistance today, and I wish you all a very Merry Christmas when it comes. And some of you will be working away on further written submissions, but we look forward to seeing you all again soon. Thank you.